Mr. Speaker, I am honored to rise in this House to make my contribution to the debate on the Homeowners Protection Bill 2017. Mr. Speaker, I propose to do two things: to put the bill in context from a social implication perspective, and then to deal with the substance of the bill. But I could start off by saying that I am greatly disappointed at this bill. I've waited for a bill to come before this House for what has now been 4 years and 10 months. And before the campaign completed in May of last year, and we came into this House for some period before that. And more than me waiting, Mr. Speaker, the people of the country have been waiting. Because what this bill deals with, or what it should be attempting to deal with, is stemming the greatest transfer of wealth that we've ever seen in the history of this country from the middle class and the working class to others. That's what it should be about, but it's not what it's about. Homeowners have been losing homes in the Bahamas for decades. This became a particular national issue in around approximately 2009, Mr. Speaker, when the impact on our economy, whether because of international pressures or because of local mismanagement, was such that a lot of people found themselves in dire straits and were losing their homes. And this became an issue that the PLP campaigned on, and I in particular campaigned on this issue. Frankly, I brought the issue to the PLP to say this is an issue we ought to champion. And I was grateful when the PLP adopted it, and we campaigned on this issue. There were two previous, I call them informal attempts because they did not involve legislation, by the government to address this issue. And both of them were resounding failures. It's not a political criticism, it's a lamentable fact that persons who should have been helped were not helped for the better part of 5 years, up to this moment in this House. The member for Centerville said at some point that the grand total of 4 to 5 people had been helped. 4 to 5 people out of a country of thousands of homes being lost. And nonetheless, this bill, the substance which this bill should address, did not rise to the level of urgency that it was brought to this House in a timely fashion and in a substantive way to stem the tide of loss of our people. Speaker, it's no secret that I laid a bill before this House in the latter part of 2015. A very simple bill to amend the Conveyancing Law Property Act to give certain discretions and jurisdictions to our Supreme Court. I'll speak more on that in a minute. But that has not been debated in this House yet. And I say only this with respect to that bill, Mr. Speaker, and respect to the bill before us. The bill before us does not anywhere in it mention the Conveyancing Law Property Act, does not purport to amend it in any fashion whatsoever. And so we now come to the point of recognizing that the bill before this House is not in conflict or dealing with the same substantive area as the bill that I tabled before this House in 2015. That's the first point I'm making. The second point is after this bill is passed, as distasteful and insubstantial as this bill is, I have no doubt it will be passed. But after it is passed, the next bill on the agenda of this House dealing with this matter is my bill that I tabled in November 2015. Mr. Speaker, I will call for the bill to be debated once this is cleared out of the way. And I will show why as I go forward with this. And let the rulings fall where they may, let the resolutions fall, let the voting fall. I want the people of the country to see what their representatives are doing in this House with respect to this urgent matter. So, Mr. Speaker, I propose to deal with it in this way. First, I'll ask the question, what is the issue that is pressing upon our country that needs to be addressed and is represented as being addressed by the bill that's before the House today? The issue is this, Mr. Speaker. Homes have been lost in the thousands. Notice I didn't say houses, homes. The whole point of this type of legislation is to protect homes. And there's a distinction between a house and a home. It's to protect families. It is to make sure that we do not, by our inaction in this house, contribute to the destruction of the family unit in our country. It is also to ensure that there is the ability of persons to save wealth. I've said repeatedly there were four foundations we built this country on. We could constantly go through them. It's not a fiction of my imagination or figment. This country was built on securing health, securing education, securing access to jobs, and securing the creation and accumulation of wealth, which for most people meant home ownership, and for others should have meant entrepreneurship, which we haven't gone into, but that's a different debate. But for most people, it was home ownership. It became the largest revenue pool for persons to pass from one generation to the next, the largest source of wealth. And so homes have been lost in the thousands. Families have been divided. And I hear certain members of this house come into this place and talk about how things are wonderful in this country, and particularly in Grand Bahama. Wonderful, where families have been divided and have had to go to Bimini and elsewhere in this country and leave children, leave spouses in Grand Bahama to fend as best they could. Where families are today still living in the dilapidated hotels over there and on the beaches and cars and so on. Today, hundreds of millions of dollars since 2012, this is still going on. Frankly, billions of dollars since 2012. This is still going on. And the loss of the home has been the loss of the prospect of accumulating wealth for their golden age and for passage, if they so chose, to their children and to their families. Gone. And as an ancillary thought, there are people in the country who've made big money on this, who've bought out vast portfolios of mortgages. Portfolios of mortgages that nonetheless can be tamed by this House in passing a responsible piece of legislation. Most people have no prospect of rebuilding those assets, Mr. Speaker. Their age, their financial condition, no prospect whatsoever. No transparency, no oversight. And here we are, 4 years and 10 months later. The relationship between the borrowers and the lenders in this country, Mr. Speaker, are largely unregulated. The Act refers to the entities, those two parties in their legal name of mortgagor and mortgagee. And I just want to comment on that because most people reading the Act have no idea what a mortgagor and what a mortgagee is. Most people will assume that the mortgagor is the bank. A mortgage is where you transfer your property to a lender in exchange for them giving you money, and with the condition that if you pay them back, they will transfer the property back to you. So the mortgage instrument you initiate, and therefore you are the mortgagor. The borrower is the mortgagor. The bank or the lender is the mortgagee. And that relationship is largely unregulated. We feel it every day when we go in a bank, and banks can invent overnight new fees. Fees that never existed before. You go in the bank now, there's a banking fee for this and for that, and God only knows what else they have thought up in the background to bring out one of these days, because no one has laid down a law saying you cannot pass these fees without these fees being approved by someone of authority, someone who's been elected by the people. So the people are largely at the mercy of these banks. Banks have penalty provisions in their documents. Although the common law says that whatever is penal is also unenforceable, no one protects them. There's no consumer agency to do it. People have titles, but they don't do it. And so the banks come right out and say in your mortgage document, in the event that you do not pay, we will impose a penalty interest. Although the common law and the lawyers understand that once they say that, that's not legal anymore. There's a small window of legality for it, but not when you go from 10% to 15, 16, 18%. That's clearly outside the realm of what can be legal in common law. But it's done. No one says anything about it. People have to pay out their noses, and it just goes on. But let me get to the important point so people can understand what we're dealing with here. In our law today, if a lender, whether it's a bank, an insurance company, anyone who loaned you some money to borrow to buy a house. If a lender says that you have default and wants to sell that house, there is no requirement for the lender to go to court to sell your house. We all know that because lenders don't go to court. No judicial oversight of the exercise of the power of sale. None. And so you've been paying all your life, and this is an experience I've gone through, Mr. Speaker. A woman of 65 years old or so, who'd been paying for 19 years on a 20-year mortgage, who had retired and didn't have a job, and just was looking for a little extension of time to allow her to pay off that one last year. We went to court, and that insurance company took that woman's condominium. And the courts had no power, it's not their fault, no power whatsoever to do anything. But if they had had the power to extend the mortgage period and reduce the monthly sum, this woman would have been able to complete her payments and have the benefit of which she'd been paying for 19 years. No judicial oversight of the exercise of the power of sale. No oversight of the collusion which we all believe happens between the bankers, and I'm not saying the banking institutions, but individuals who work in those institutions and people they know. And that is perpetuated, as I will show, under the bill that's before this House. Perpetuated. I'll get to it. It's also led to a glut of homes on the market. Most other countries understand you're not allowed to do this, that this makes no sense. Why should the banks be able to take all the homes? Because then there'll just be a bunch of homes on the market, which has two implications, worldwide and in this country. One, neighborhoods start to fall into disrepair, because as homes are taken, they're not upkept. The banks will not expend all of that money to keep the homes going. Homes get vandalized. They're places where people go in and do drugs or whatever else they're doing, and neighborhoods are brought into peril. And that glut of homes on the market also leads to a stagnation of the construction industry. We've seen all of this. All of this. Water under the bridge, I suppose, for some people, but real life for the majority of people who've gone through this. So what's the way other countries have dealt with this? This must have happened somewhere before. Other countries have dealt with this very simply. The bill that was tabled by me in the House in 2015 adopted the approach that the United Kingdom adopted, of saying, listen, it's under the Administration of Justice Act 1970. It's been around for 47 years, almost half a century. And it takes a very simple approach. If you want to sell a dwelling home, and only a dwelling home, sell the car, sell their empty lot, sell their commercial land, sell whatever you want. But if you want to sell a dwelling home, you cannot exercise that power of sale without going to the court first. That's what the UK does. And when you go to the court and the judges have a discretion under the Administration of Justice Act and under the bill that I tabled before the House in 2015, would have a discretion to say, now that you're before us, we're going to do a couple of things. One, we're going to look at the entire transaction, and everything that you did that was penal, we're going to undo. All of these penal interest rates that you impose, we're going to net them out, because you had no right to do it. So now that you're before us, we're going to fix that. Secondly, we will exercise the power to extend the mortgage period. And by extending the mortgage period, we reduce the monthly sum that's being paid by these borrowers. And therefore, the bank makes more money over an extended period of time, but the borrower pays less on a monthly basis and therefore can save the home. It's a sensible approach. Obviously sensible. I mean, there are some other ancillary powers that come with it, but that's the meat of it. The US has done something similar. They've simply said, listen, if you're about to lose your home, just file bankruptcy, and no one will be able to take your home. Because they understand the implication of that to your country as a whole, and to the fabric of the country. So what is the Bahamas' position at this second in time? There are no protections for homes. What would the bill that I tabled in 2015 have done? It would have brought in the jurisdiction of the Administration of Justice Act in the UK. and was said you could not exercise the power of sale in respect of homes without going to court first, and would have brought justice and equity between the parties when you got to court. So the magic question is, what does the bill before the House today do? So let's go through it. The bill has a lot of provisions. Let's start with Section 4. Where a mortgagor, meaning the borrower, is in breach of the mortgage agreement, the mortgagee, meaning the lender, shall not institute proceedings before the court in respect of the breach unless it has been served upon the mortgagor either personally or by registered post at least 30 days prior to instituting such proceedings, a notice in writing. Some people will read that and believe that means you can't sell a house without going to court. You know, it doesn't say that. It says if the lender chooses to go to court. He issues his 30-day notice stating the nature of the breach, etc., etc., and then the mortgagor, this is Section 5, meaning the borrower, may apply to the court for relief. So when you read Sections 4, 5, and 6 together, it has nothing to do with protecting the borrower. It has to do with saying, bank, insurance company, lender, if you choose to go to court, now, if you choose to do that, to exercise your power of sale after giving you a 30 days notice, the borrower can go to court. It's a totally different situation, especially in a country where you have people who can't even pay the mortgage. How are they going to hire a lawyer to go to court? How? That's the very issue. But in other countries, when they turn it around and say, as the lender, you must go to court, it's not the issue. So we do it the other way in Sections 4, 5, and 6. We say, you know, do what you want, give them 30 days notice, and after 30 days notice, you include all of these provisions, and the members of the family or the borrower have a right to apply to court, to go to court. And it says, let me just start to introduce something that is shocking to me when you read this bill. And let me add to this so people can get it. The only time today, and under this act, that the lender has to go to court is if they sell your house and you will not get out, and they need an order for possession. Then they have to go to court. And then Section 6 says, you know, if they want to sell your house and you go to court, then here's the relief the court can give you, the borrower. The court can say, listen, if it is likely within 6 months that you'll be able to pay the principal and accrued interest, remedy any default, or pay arrears, then the court may adjourn it, give judgment, stay or suspend judgment for a maximum of 6 months. You know why that's interesting? Look at Section 6.1a. If the mortgagor is likely within 6 months to be able to pay principal and accrued interest. Not pay accrued principal, you know, and accrued interest. Principal. And again, that flies over the head of most people. Why that's important is most of these mortgages say once you're in default, the entire mortgage becomes due. The entire principal becomes due. And so under 6.1a, you go to the court for relief, even when they have given you a notice and you are forced to bear the financial burden of hiring a lawyer and going to court, still, show that you could pay principal and accrued interest, not accrued principal. And I'm going to further develop this point. It's even expanded more explicitly later on. Principal. Anyway, 4, 5, and 6 deal with what happens if the borrower takes it upon himself within that period of time to go to court. Most people will never be able to do that because they're in default. Give notice prior to exercising non-judicial power of sale. They recognize what is going on, you know, that there's a non-judicial exercise of the power of sale. Still, under this bill. So where the mortgagor, the borrower, is in breach of the mortgage agreement, the mortgagee, lender, shall not exercise the power of sale conferred by any other law unless there has been served upon the mortgagor personally or by registered mail at least 30 days prior written notice of intention to exercise it. Fine. Again, the mortgagor may apply to the court to postpone the sale, and he must make that application within 28 days. Just remember, this is the person who can't even afford a lawyer because they can't afford to pay their mortgage. But somehow, you get served with this letter, and within 28 days, your lawyer is up to speed and has filed that application in court. Let's assume you get past that hurdle, which most people, frankly, I don't think can. Here's what happens. Section 9. Power of the court to grant relief from mortgagees exercise the power of sale, which in Section 8 they rightly call the non-judicial exercise of the power of sale. So here we go. The court may again grant relief if you pay sums due under the mortgage, etc. But go to Section 2. An order under subsection 1 shall not be made unless the mortgager satisfies the court that the following conditions exist in relation to him. So now it's the borrower saying to the court, I can satisfy you of the following. Look at A. That a sum equal to at least 1/2 of the amount of the principal, not accrued principal, the principal and accrued interest are being paid to the mortgagee. Think about what that means. Let me break it down for you. Someone goes and gets a 20-year mortgage. Everyone in this country can check this point. Go to your bank. Look at the amortization table. Not a penny on your principal will be paid off for the first 10 years. But Section 9(2)(a) says you can't make an application to the court unless half of your principal is being paid off. Go and look at it. Okay, let's leave not a penny. Let's leave not a penny, but the interest is paid in the first half-life of the mortgage, the majority of it. And if you get to paying off half the principal, by and large that happens in year 15. Go and look at the amortization tables. It certainly doesn't happen before. To say that you've paid off half of the principal will not happen in a half-life of the mortgage. You're paying interest. You're paying interest. But Section 9(2)(a) says no court can make an order under this unless a sum equal to at least half of the amount of the principal and accrued interest are being paid to the mortgagee. So your trigger, even in respect of this non-judicial exercise of the power of sale, is to come to court. You come to court and I represent a bank and I say, listen, it's interesting what you're saying, but show me you paid off half the principal. You haven't. It says exactly that. Half the amount of the principal. Not accrued principal. There's no concept in here of accrued principal. It's provided for those who want to have this discussion, accrued principal is provided for under the Conveyancing Law of Property Act, where the exercise of the power of sale happens after 2 months arrears of principal or 3 months arrears of interest. That's accrued principal. That's accrued interest. Here, this is a totally different concept. Totally different concept. An order under subsection 1 shall not be made by the court unless the borrower satisfies the court that the following conditions exist in relation to him. Condition A, that a sum equal to at least 1/2 of the amount of the principal and accrued interest are being paid to the mortgagee. I'm not going to be distracted by this, Mr. Speaker. If anyone wants to take a point of order, just get up and take the point of order. My point is this. Read it literally. 2 tests. One in relation to principal and one in relation to interest. That at least half of the principal has been paid. That's year 14 or 15 of a 20-year mortgage. Look at C. That he has been in occupation of dwelling home for a period of not less than 20% of the original mortgage term. I don't even know why that's there. What that's basically saying, it's a dwelling home, but if you couldn't afford the mortgage, even if you had paid off half the principal, if you were renting it all these years so that you have someplace to be in afterwards, you don't qualify. Occupation. Why is the concept of occupation even there? And I go back to the original point. 9(1)(a), that they pay any sums due under the mortgage. No provision in this entire act to say you cannot have a term which says upon default the entire principal becomes due. That's in all kinds of mortgages. And so when you look at 9(1)(a), pay any sums due under the mortgage, and you have a simple clause in the mortgage, upon default the entire mortgage becomes due, that's the same as paying the mortgage off. And then 9(6). None of this applies to any legal proceedings existing at the coming into operation of this act. Even if you squeeze your way through all of what I've just said. All of those people out there who are suffering already, none of them get relief from this. None. Go to 10. Mortgagees, duty of fair dealing. Well, it's a great subheading, and you'd love to see that there because, you know, people are in collusion. So you expect to see something substantial there. A mortgagee, meaning the bank or lender, in the exercise of power of sale, which is the non-judicial power of sale, shall not engage in unfair, deceptive, or abusive acts or practices. When you read that, you expect to turn the page and see subsections 2, 3, 4, fleshing out what that means. What does that mean? Unfair, deceptive, or abusive acts or practices. This isn't defined anywhere. Nowhere. But yet still this is the fundamental problem in the country. You know what's troubling to me, Mr. Speaker? You then move on from those two illusory grouping of sections that make you think you have something that's not really there. Now come to section 11 and move from there. And you see the other part of the act. The benefits that come to the lender under this act. Those are not illusory. They're real. Look at this. We've always had this concept going on between lawyers and court, that if you get to sell my property, yes, you don't have an obligation to get the exact market value, but you can't sell it for any figure whatsoever. You must exercise your fiduciary obligation to at least get a decent price. This says the opposite, you know. This finally would put to rest in favor of the lender that question. Look at this. Section 11. Where a mortgagee, meaning a lender, has failed to secure a sale of the property at market value within 6 months from the date of the mortgage, issued a notice of default to the borrower, to the mortgagor, obtained vacant possession, the mortgagee, again the lender, at his option, may, after giving notice to the mortgagor, proceed to accept the highest qualifying bid offered in writing. And in case you didn't know the implications of that, go to subsection 2B. In the event that the property is sold at less than market value, the mortgagee, the lender, may pursue the mortgagor for the recovery of any sums remaining on the mortgage debt after said sale. Look at A. In the exercise of the power of sale, the mortgage property may be sold at less than the market value. Then these kind of very limited opportunities for the borrower. Within 10 days of receipt of the notice, they can run to court to pay the amount of principal and accrued interest at a specified time. Again, not accrued principal, just principal. To remedy default, to apply to the court for relief. And it goes on and on and on. Subsection 6, the mortgagee, meaning the lender, shall at its option accept the highest price offered for the sale of the property, even if the price is less than the market value, and shall on receipt of the proceeds apply the price. I want to rush because I have 2 minutes more. I just want to point out something. Prohibition against sale to related parties. There are other stuff I'm passing over, but this is so egregious. Let me go to this in my last minute and 30 seconds. Section 12. Where a mortgagee, meaning the lender, exercises power of sale, the mortgagee shall not sell the property to director or employee of the financial institution, immediate family members, etc., etc. But look at C. A company beneficially owned by a director or employee of the financial institution. What about a company owned by immediate family members? It's not there, you know. So you can get past this by saying, I'm not going to sell it to my immediate family member. I'm going to let them incorporate a company and sell it to their company. Because the only companies you can't sell it to are companies owned by directors or employees of the institution. Let's look at 1D. Any person who by nature of their intimate relationship with director, employee, or financial institution will be given more favorable consideration as a result of that. What does that mean? That means you go to court and try to prove what that means. Whereas if you want to say don't sell to family members and their companies, just say don't sell to family members and their companies. Look at 12.2. For the purpose of the subsection, immediate family shall include spouse, children, parents, sibling, and cousins. What happened to nephew, nieces, uncles, and aunts? What happens to companies owned by them? What happened to any relationship in which they are involved? And even above, where you say company owned by a family member, what does that mean, own? Beneficially owned. A company beneficially owned by a director. If the director only owns 50% of the company, does he beneficially own the company? No. He beneficially owns a shareholding in the company. He doesn't fall under this prohibition. And on and on and on it goes. Mr. Speaker, we can do better than this. Marcus City won't support this. Thank you, Mr. Speaker.
Thank you, Honourable Member.